All rise. The Court of Appeals, First and Fourth District of Ohio, with the Honorable Kenneth Krause presiding, is now in session. Please be seated.
Good morning, everyone. Welcome to the First District Court of Appeals. We have two cases to be argued today, and the first case is In Re KB, case number C-220463, 464, and 465. And my understanding is we have Keith Sauter for the state.
That's correct.
And Jessica Moss?
Yes, Your Honor.
Okay, for the defense. And then we're going to take a brief pause, and Judge Kinsley is going to leave. Judge Bach will be taking her place for the second case, Mount Lookout Community Council versus City of Cincinnati, case number C-220533. And who's going to be arguing for appellant?
Your Honor, Sean Suter.
Okay, great. And for appellee board or City of Cincinnati?
Kevin Tig, Your Honor.
Okay, and is it L&D Real Estate Holdings?
That's right. Kathy Ryan.
Okay, perfect. All right, so we'll start with In Re KB.
Good morning, Your Honors. How are you?
Good morning. Would you like to reserve time?
Yeah, Judge, if I could reserve 5 minutes, that'd be great. I don't have a lot to add to what's in Ms. Steer's brief. This is a relatively straightforward issue. This is a bind-over matter that arose from two separate incidents out of shootings that occurred in Westwood within about a 1-month period. Detective Combs of the Cincinnati Police Department investigated both of these. There was a robbery that occurred on Montrose in which Donald Scott was the prosecuting witness, gave police info about 3 individuals. That case went cold for a while, but fingerprint evidence subsequently led Detective Combs to investigate another shooting that happened on Baltimore, and in that case, the prosecuting witness was Jeray Carter. When Combs went to talk to Carter, Carter stated that he had been with the 2 individuals that occurred in the first shooting. It was the night of the Scott offense, and one of those individuals was the defendant in this case, KB. Carter was able to describe the events that surrounded the Scott robbery. He indicated that he had known KB for a long time. He considered him to be a friend. He knew where KB lived and was otherwise familiar with him, having known him for a long time. Carter identified KB as one of the assailants in a carjacking in which he was the prosecuting witness. He indicated that the other individual shot him in the hand, but that KB, the defendant in this case, had shot him in the back. Based on all of this evidence, there were charges of aggravated robbery, felonious assault, and attempted murder brought in the case in which Carter was the prosecuting witness. The state moved for bind over, and the case proceeded to a probable cause hearing, at which time the Detective Combs testified as to both the Scott offense and to the Carter offense. As for the Carter offense, which is the subject of this case, Detective Combs testified in accordance with what I just said, that he met with the victim and the prosecuting witness. The prosecuting witness was able to clearly identify KB as one of the participants in the carjacking because he had known him for a long time.
Wasn't there like a photo or some Facebook shown to him? Or
There might have
I
been,
was
Judge. There was a
confused on
complete.
that.
I'm sorry, I didn't mean to.
I was just confused on whether he was actually shown a photo and he identified KB in a photo.
That wasn't clear from the record to me either, Judge. I don't know, but there was a complete lineup shown to Scott. There's no doubt about that. But really, the identification wasn't so much of an issue in the Carter case because he had known him for a long time, and essentially Carter conceded that he was present with KB on the night of the first offense. Didn't exactly admit that he participated in it, but it certainly seemed that way. And of course, he had known him for a long time, so that identification really wasn't the primary focus in this. At the end of the probable cause hearing, the court found that there was probable cause as to the Scott offense, but not as to the Carter offense. The state contends that that was erroneous, that the state presented sufficient evidence to at least provide a reasonable belief that KB had committed a crime with respect to the Carter offense.
Counsel, can you address whether there's any independent corroboration of Carter's story in the record?
Judge, I think it's no physical evidence for sure. They didn't have the ballistics evidence and that sort of thing. There was no lineup. But I think just in terms of the internal consistency, every indication that Carter knew what happened in the other offense and he'd been associated with KB. He was able to talk about what was portrayed in the video that happened at the Scott offense. So there were a lot of check marks that he was able to check off to indicate that he was being truthful with respect to KB and both of the offenses, even though there was no physical evidence presented. The fingerprint evidence was presented, but at the probable cause hearing, they didn't go into that very much to indicate in what way the AFIS hit linked the two crimes.
And did Smith's confession relate only to the Scott situation, or was it also the Carter situation?
It was to the Scott situation, but it was it all tied together, I'll put it that way, even if there wasn't a direct indication of what he had done in both offenses. There was at least enough to tie this together to indicate that Carter was being truthful and was a credible witness or a credible person when he stated that KB was involved in the Carter offense.
Can we consider the evidence of the Scott offense in terms of how it corroborates Carter's testimony to bolster what Carter was saying here?
I think so, Judge, because I think that, if credibility is the question, the fact that he told the truth and was able to give specifics about both offenses, I think that does corroborate the testimony or his statement with respect to the Carter offense and adds another layer of credibility to the story as a whole.
It sounds like, so with the Carter offense, I think you agree that the only thing we have is Carter's hearsay testimony.
Correct, yes.
So would that, if we didn't have his testimony regarding the other case, would that be enough, just as hearsay testimony?
I think normally it would, Judge, because hearsay is admissible in a probable cause hearing, and I think we could accept that for the truth of what's asserted. I think that that his statement with respect to the Scott offense just adds another layer to the credibility. But I think even without that, I think it would be enough because he had firsthand knowledge of the offense. He was intimately aware or familiar with KB. Could testify as to what he did in both of these offenses.
It just seems like more of the cases that I've been looking at have had, certainly the hearsay testimony is admissible. There's no question. I don't think the judge said it wasn't. But there's always extra corroborating information. like the other case that we had.
Yeah.
And here we don't have that unless you take into account the other case, right?
Yeah, and I think one of the reasons that probably the state didn't feel the necessity of putting on a lot of other evidence with, like, for lineup, ballistics evidence, video evidence like they did in the Scott case, was that it was clear that Carter knew the assailant in this case, and kind of rises and falls with his statement.
Well, he was also subpoenaed and didn't show up.
Yeah, exactly.
So it sounds like the state was expecting to actually have the victim
I
testify.
think that's a big part of it too, yes, Your Honor.
Yeah.
But unless there are any questions, that's all I have.
I don't know.
Okay, thank you very much.
Good morning, Your Honors. Jessica Moss on behalf of the appellate KB. We're asking this court uphold the juvenile court's finding that there was no probable cause for the 3 charges that are the subject of this appeal. And the state here has to produce evidence, credible evidence of every element of the offense, and that didn't happen here. It has to be more than just a mere suspicion of guilt, although it does not have to be to the level of beyond a reasonable doubt. Here again.
Let me ask you, ma'am. You say that they have to produce evidence. I agree, they have to produce evidence, but the testimony of Detective Combs concerning Mr. Carter was that he said he was shot in the front, I think the back, I think the hand, car was stolen, and he knows the people. What element was missed, if you believe what Detective Combs said?
So there are several elements that are missing. First of all, we know that Detective Combs wasn't even the officer investigating the allegations into May 22nd. And also we know that Carter didn't show up. But in regard to an alleged theft of a vehicle, we don't know where the vehicle was even located, if it was in the same place that Carter is alleging that this incident happened, to know if it was moved, since his assertion to Detective Combs was that KB and Antonio Smith took the vehicle. There's no evidence of a gun being used. Detective Combs' testimony was just that there was bandages on Carter's hand and that he was walking with a cane. There was no bullets recovered or shell casings recovered, or even any testimony about investigation about looking for any bullets or shell casings. There was no medical records introduced to show any injury for Carter, asserting that KB shot him in the back. There was no indication of whether Carter had ever walked with a cane before that day. So just the fact that he's walking with a cane is not enough to show that that KB allegedly shot him, that there was any serious physical injury to Carter.
So you're saying that the hearsay that was presented was not credible because there was no corroboration?
Correct.
Okay.
Counsel, I'd like to ask you about the circumstance of Carter's statement, and considering any indicia in the statement itself that it might have been reliable, looking, for example, to things like whether it was a dying declaration or it was a present sense impression. When were these statements by Carter made, and under what circumstances were they made?
So there was very little testimony in the record about this. So Detective Combs, he was the one investigating the April incident, not the May incident where Carter was the alleged victim. The conversation with Combs and Carter happened when Carter was released from the hospital. There was no telling nothing in the record about how long Carter was in the hospital. And the testimony was only that Combs talked to Carter a little bit about what happened in May, and the conversation mostly concerned what happened in April. And so it was just very little information from Carter about what happened on the day that he's alleging that he was the victim.
Why can't we take into consideration that Carter's testimony regarding the murder case was actually somewhat corroborated? And so with that, why couldn't we say, well, okay, clearly he has credible, the hearsay is credible in this case? Because you're saying because the hearsay wasn't corroborated with his particular case, it's not credible, but in fact, some of the testimony or information that he had given was corroborated in the other case. So why can't we just consider that too?
I think we're looking at a situation where he is involved or allegedly involved with the first situation, whereas he's alleging that he's a victim in the second. But there was more than just his testimony that, or his statements to Detective Combs that made that first incident enough for probable cause. You had the confession by Antonio Smith.
I understand that there was more information for probable cause, but I'm just talking about Carter's credibility, because that's your issue here, is that because there was no other corroboration with regard to his case, that his hearsay testimony or his hearsay information wasn't credible, right? That's what your argument is.
It's that it's not credible, and that there was also not this other evidence of things like a gun being used or an actual injury that would have been allegedly caused by KB, or that there was a theft of a vehicle.
Right. So we can't, but can we consider the other case?
I don't think we can consider the other case other than looking at what the differences are to see this is a case, the first case is a case where, more evidence is introduced to get to probable cause, and looking at that as the example and what should happen at a probable cause hearing in order to get probable cause to bind a child over to adult court. And the juvenile court has to act as this gatekeeper to make sure that there's enough. And here they're saying that there wasn't because there wasn't enough evidence. There wasn't enough credibility. And the fact that Carter didn't show up even when he's subpoenaed, I think really adds to the fact that his information about what happened when he was an alleged victim is not credible here.
Counsel, what other evidence would have existed? I'm thinking of situations where there might only be a witness or a person's testimony. And so what would have constituted probable cause in a case like this?
I think what's interesting here is the fact that it doesn't even seem like the police looked for, if there was any video recordings of what Carter's alleging happened, just like that they did for the Scott incident. There's no indication of them searching for shell casings or bullets like they did in the Scott incident. The only testimony was that they fingerprinted Carter's car, and the only thing that came back from that was the fingerprint hit for Antonio Smith. There was no fingerprint hit for KB, despite Carter saying that KB was in the vehicle, which again goes to the lack of credibility for Carter. We also have this issue of the fact that there's no lineup or photo array of KB that Carter did. The only photo array was for the case that's not subject of this appeal. So there's no indication that KB is the actual person that Carter is referring to for the incident on May 22nd of 2020.
I thought there was some sort of Facebook shown to Carter.
There was no actual photo lineup. There was some confusing testimony, and the whole transcript is pretty confusing because it's going from one incident to the other incident. Detective Combs didn't testify that he was the one to show Carter any photos, or that Detective Combs even saw any photos. So if there were any photos shown, Detective Combs couldn't have been the one to say, yes, that's the person that Carter identified as being KB, because that testimony was not in the record. Again, overall, there is no evidence. There's not enough to get to that probable cause determination. There's only a mere suspicion as to KB. There needs to be more. And again, you can look to the fact of what was produced as to the Scott incident to show what should happen here. So for those reasons, we ask that this court uphold the juvenile court's decision dismissing the case, finding no probable cause. Thank you.
Thank you. So sorry, you have 8 minutes?
Okay, great. The only thing I want to address are some of the questions that the panel had on my first go around here. The officer, Detective Combs, did show Carter photos of AS and of the defendant in this case, and he was able to, and Mr. Carter was able to identify both of those individuals, even though it wasn't a lineup. And I think that under the circumstances, because the assailants were known, there was no need for a lineup in that. And as to whether AS implicated KB in the Carter offense, what Detective Combs was, he said he was very reluctant to name the other person involved, but the name Mar, which was one of the nicknames for the defendant in this case, did come up through AS and his mother, so at least there was some indication that there was involvement in both cases. And if there are no further questions, that's all I have.
Counsel, I do have a question. What do we make of this fingerprint evidence from the car? The fact that only AS's fingerprints were found and not KB's?
Yeah, I don't think we can make a lot of that. I mean, it wasn't, there wasn't a lot of detail in the probable cause hearing to suggest how it linked the crimes or who was involved in both. But I think that the fact that one person or the KB might not have had prints at both scenes, I think is something the court could take into consideration, but I certainly don't think it's dispositive. Unless there are any questions, that's all I have.
Thank you.
All right, thanks.
Thank you both for your arguments this morning. The case is now submitted, and we will issue a timely decision. If the next case would like to come forward and get situated. My understanding is that the appellees are going to split time evenly. Is that correct?
Yeah.
Okay. And Mr. Suter, how much time would you like for rebuttal?
I'd like to reserve any additional time for rebuttal, if possible. Whatever's left,
You don't have a specific amount?
about 5 minutes.
You want 5? Okay.
Please.
I'll let you know when you have about a minute of your first part, and you can decide what you want to do at
Okay,
that point.
appreciate that, thank you.
So whenever you're ready.
Oh, thank you. This is my co-counsel, J.P. Berlin.
Hello.
Good morning, Your Honor.
So the yellow light will come on when you have about a minute left.
Oh, great, okay.
Okay?
Good morning, Your Honors. My name is Sean Suter. I am attorney for the appellant, in this case, Mount Lookout Community Council. So in this case, is all about the use variance. It's a legal issue. The city is asking this court to uphold the use of the use variance to approve a non-use. I think the key term here is going to be use. And the city has allowed the developer who made application to demolish 4 properties that are directly adjacent to Mount Lookout Square. They're within the Mount Lookout Urban Design Overlay District. They're allowed to be used by right for multifamily, which is what they want to use the property for, so the base zoning is by right. But they are not, or were not allowed under the ordinance, under the zoning code at the time, to demolish the buildings. That was only allowed if the buildings were determined to be an emergency situation, such as if they had burned, and this chief building official allowed them to be demolished. So it was a no demolition rule at the time in the zoning code in an urban design overlay district.
So now the code lets them demolish?
So the city changed the law.
Okay.
In the interim here, I believe early in 2022, they can tell you more about that, but the city changed the law. Essentially now you can, if the city determines that the replacement use is better than what's coming down.
So they would have to just go back and reapply under the new?
I haven't worked through that exactly, Your Honor. I guess they possibly could. I don't know. There may be, the laws changed, so I don't know if res judicata would apply. We haven't worked through that. At this point, we're asking this court to overrule what the city has done to date, which is grant a use variance to allow for the demolition of these buildings, which is not a use. Use variances, according to the Supreme Court of Ohio and in planning jurisprudence, use variances are extraordinary administrative remedies. What they allow the city to do is allow a use of property. So, for example, in the Showmaker case, a use of property being a commercial use in a residential zone, allowing a use of property that is not allowed because the uses that are allowed, whether by right or conditionally, if the property owner was confined to those uses, it would be an evisceration of their property rights. So it's an escape valve for a take. But the key here is the term use, which is a term of art in land use law. Use being the principal primary use of property. Here it's odd because the city has allowed them to essentially remove the use of property. So how can we have a use variance that allows the removal or the actual evisceration of the value of the property? And that's where this decision by the city is really contrary to the way use variances have been defined and confined by the Supreme Court of Ohio.
Mr. Suter, I think you said this earlier, and I know I've read it. I just want to clarify.
Yes.
So the ultimate use that they will be using, assuming that they are allowed to demolish the property, is already permitted under the zoning code.
That is correct, Your Honor.
Thank you.
And so there's been no other court that has said that demolition equals a use?
No, Your Honor.
Anywhere?
This would be unprecedented. It would turn land use law on its head, essentially, in the first appellate district, would be different than any of the other districts in Ohio. It's unnecessary to rule in this manner because, again, it would be contrary to the Ohio Supreme Court's definition of a use variance. It would also be contrary to how the use variance is applied in every other jurisdiction in Ohio.
But it seems like if the law hadn't been amended, as you say it has been, they would have been stuck with not being able to demolish this property, right?
Not exactly, Your Honor. There were other options available in the city of Cincinnati. Two options. Well, they actually had three options. One option, two options are legislative and one is judicial. The first legislative option would be what's called a notwithstanding ordinance. It's kind of a unique thing the city of Cincinnati has. It's a process where you can ask city council to vary their laws for extraordinary circumstances. And this court has upheld that as being lawful. I was actually involved in the case on behalf of the city, 2014, I think it was, in State XREL Phillips Supply Company, where the court said that the city council, which makes the laws, can vary the laws, right, in a determination of extraordinary circumstances. So that was available to them. They could have gone in and said, you know what, and this happens a lot. For example, a good example of a notwithstanding ordinance is the Bengals bubble. That was done by notwithstanding ordinance. That was allowed to be built. 3CDC uses them all the time. A lot of people do, where there's just no way out, right? And so the legislative path is the way out. The second way they could have done it is gotten a text amendment and said, you know, look, this is unreasonable. This is a taking of my property. Can you either remove these properties from the urban design overlay districts so that this no demolition rule doesn't apply, or can you somehow accept us out of this or change the law? Now, the city did ultimately change the law to provide an administrative mechanism to allow for demolition if certain findings were made, but they could have attempted all of that. But I think this was a hurry up. We want to help get this development jump-started, and it was actually not applied for by the applicant, the developer. It was the city's recommendation at the ZBA hearing that they consider a use variance.
Well, right. It was, yeah, to me, that sounds like, of course, that's the next step that they're going to do. If it's recommended to them, well, why don't you apply for a use variance?
Oh, I can't blame the developer, Your Honor, certainly. If it was teed up on a silver platter for them to go down that process, and it was approved. But from my client's perspective, who is a community council who's looking out for Mount Lookout Square, the law, those UDODs are put in place. I think there are, I don't remember how many of them, 10 or 15 of them across the city that cover places like Hyde Park Square, Mount Lookout Square, our business districts. It was put in place to preserve those, unless the building had burned down, essentially, or was condemned, essentially. Then you could tear it down and build something new. But the idea was to preserve those districts. Now, whether that's good or bad law, clearly the city council's changed that law now to allow for some administrative process, to allow for demolitions in certain circumstances. That's a policy question for the city council. But the use variance is not an appropriate means to get them where they wanted to be. There were at least two legislative options. And then the third option, the developer could have gone to the city and said, pay me for the property. This is a taking. And that's perfectly okay. I think takings get a bad rap, and maybe they're not favored, right? But that is an option under the Constitution, that if the city is going to eviscerate your rights, they pay you for them and you move on. So there were options. I don't know, you can make the judgment of whether they're good or bad options, but there were options. And the use variance is not an option under Ohio law. That's the key. So
what is this, I mean, if we were to rule that demolition is a use, what are the implications of that?
Well, that's a great question. So, for one, you never see the term demolition as a use. That would fall contrary to the Ohio case law relative to what a use is. A use is a primary use of the property, right? So retail, office, residential, how are you actually using it? Demolition is a part of the construction process. It's not a use. Vacant land is not a use. Vacant land is a non-use. And demolition, again, if you were to do that, you would have to then say, well, construction is a use. Well, that's an interim, temporary, actual construction process or piece of the process. It's not a principal use of the property. What is the principal use of the property? These properties were being used when they made application to tear them down, or they had been used at least recently as offices. And so there was an actual use of the property. So to say demolition is a use you'd be able to substitute, like I said, a construction process for a use anywhere in the first district. And I think that would be a reach too far expanding what the use variance is. The use variance could be, the way the city's using the use variance is an escape valve for anything.
Yeah. Let me ask you a question. I'll follow up on that because
Yes.
I certainly understand your argument. Demolition is not a use, but it's a city permitted. Apparently, the developer wants to use it for a permitted use. And I think I know the answer to this question, but what about, could demolition be considered a prelude to a use?
Again, it's part of the process to get to a use, but it's not actually a use.
It's not in the code.
Correct.
Okay.
And there is no express delegation in the zoning code in Cincinnati for the zoning hearing examiner to do what he did, to substitute demolition or to give a waiver to a no demolition rule. That's not anywhere in the zoning code, so I believe that was outside of his authority and was essentially the administrative official taking legislative action.
You are at 10 minutes if you want to reserve 5.
I think I'm good at this point. Look forward to a rebuttal. Thank you.
Okay, great, thank you.
Morning, Your Honors.
Good morning.
May it please the court, Kevin Titt on behalf of the city of Cincinnati. This case is about whether or not the zoning code provides an administrative process for relief from demolitions in UDODs. The ZBA concluded it did and recognized that it was appropriate to apply the use variance standard because the property owner could not use the property in the manner it wanted.
I have two questions for you. First of all, could you find any case saying that demolition is a use?
So there are no cases in Ohio that I have found that says demolition is a use. However, there are also no cases in Ohio that I have found that says demolition is not a use.
So this hasn't been considered?
Has not been considered, as far as I know. And I believe that's what my opposing counsel has also found, because he has not cited any cases that actually say demolition is not a use. But I would like to point you to some of the cases that he cites, especially in his reply brief. The cases he cited, they actually define the term use as an activity. Now, demolition is clearly an activity. And I bring that up because I also cite another case that has signs as a use. So, that is, I would also say, an activity, much like demolition. Demolition is a use. The property owner cannot use, I believe Judge Winkler just brought this issue up. The property ultimately cannot be used by the property owner in the manner they want to use it without a demolition. So I think it goes hand in hand. They're tied together. You can't have one without the other.
But now, my understanding is these are single-family homes that are currently rented. Am I right on that? Are they multifamily homes?
So they're historically single-family homes, but they've been being used for commercial uses for at least the last 25 years, I believe.
All right. And
It's
you're
the
just-
area right across from Zips, if you're familiar with Mount Lookout Square.
So, but there are other means for the developer to be able to develop this property, though, other than the use variance, correct? I mean, I read it in the briefs, the ordinance notwithstanding, correct?
Do you mean other ways to get to demolition?
Yeah.
Yeah, so there are, but there's not an administrative process. Administrative processes are important because they're efficient and accessible. They allow people who support the process to come be represented by counsel or not be represented by counsel, put their case on in a manner that is that is more efficient and accessible than actually doing a legislative process.
But you can't actually say that there's no way for the developer to get to where the developer wants to be without this use variance.
No, so there is a way, but there's not an administrative path to relief. So without an administrative path to relief, a developer, such as in this case, would be forced to take the legislative route, which would be, they basically, I mean, a notwithstanding ordinance is a law. They have to, lobby, and they have to, what a notwithstanding ordinance does is it sets the law aside for that particular property. They can do that, or they could seek a zone change, which is what a text amendment is. But again, that is not a quick, efficient, and accessible path to relief. Because the Supreme Court has consistently recognized that property owners should be given an opportunity for administrative relief. And if an unnecessary hardship would result in carrying out the strict enforcement of that zoning regulation, a use variance is proper. And I point that out because this process wasn't created by the ZBA. The use variance standard was established by the Supreme Court of Ohio, and it is spelled out in the zoning code. Section 1445-16, which is the city's use variance standard, it codifies that unnecessary hardship standard that was established by the Supreme Court. And it does not limit use variances to uses in the use table or to the base zoning districts, as Mount Lookout suggests. The standard is meant to be flexible and apply whenever a property owner wishes to use his property, such as here, in a way not expressly or implicitly permitted by the code. And this was brought up in Mount Lookout's argument. This section was designed to avoid a situation that would otherwise create a taking.
I mean, Mr. Tidd, was an unnecessary hardship or economic infeasibility ever shown, or if it was, where was it shown?
So it was found. It was found. It was shown. It was found at the lower level, but that was not appealed. So the only issue that was appealed by Mount Lookout was whether or not the use variance was appropriate. Was an appropriate mechanism to get relief. It's important. Mount Lookout didn't actually appeal whether or not they should not have been entitled to a use variance, or whether or not the project didn't meet the different design standards or the other zoning. The only issue that was appealed here was whether or not the use of a use variance was appropriate.
So the implications of this, if we would agree with your argument, how would this apply to things like historic districts where demolition is, there's a lot of protections with historical buildings and you can only demolish them if you meet certain criteria? Could a developer just apply for a use variance to demolish a historic building?
So I think they could, but it would be a different situation because in historic districts are just different. That's not what's right in front of us right now. Those historic guidelines are very strict.
They're very strict,
Very
right?
strict,
But then I'm just
yeah.
wondering if they wanted to, if there's well, they're too strict, I'm just going to apply for a use variance.
So I don't think that would apply here. This decision would not have a bearing on that because in that situation, you actually have to show what you're going to build next. It's the guidelines are different than the UDOD district. And to go a step further on whether or not this has far-reaching effects, I don't think it does, and that is because the law has since changed. But I do want to point something out about that.
It doesn't have far-reaching effects because the law has changed
The law in UDODs, urban design overlay districts.
with the amendment?
Yeah, so it has
okay,
since changed.
okay.
But something that was interesting about that law change is that the ordinance specifically took authority to grant use variances for demolitions in urban design overlay districts away from the ZBA. So the ZBA obviously had the power to grant use variances if it was necessary to take that power away. It's just something I wanted to point out. Do you have any more questions for me?
Well, just on the application of a use variance, so if we were to hold that demolition equals a use, is any time now that a developer wants to demolish or engage in construction, would they have to apply for a use variance to do it?
To demolish?
Yeah, if they want to demolish a building or engage in, or build a building, would they have to apply for a use variance each time?
Sorry, so no. And the
Okay.
reason is UDODs were very unique in that they did not allow demolition. That's why it was unique. The other zoning districts, historic is different. But let's say the single family or residential zoning districts, when you're applying for a use variance, let's say UDF wanted to put a gas station and a mini mart on the corner of two residential streets. The demolition is not what they're applying That is not what they're applying the use variance for. The use variance would be for the commercial aspect and gas station aspect of that project.
For the use of the property.
Because the demolition is already permitted in that district. So the UDOD was unique in that it did not allow demolitions.
And you're at 7.5 if you want to split with your,
Yeah, I don't have any other questions I don't have anything else unless you have anything else for me.
I don't. Thank you.
Thank you very much.
Good morning. May it please the court. My name is Kathy Ryan on behalf of the intervening appellees, L&D Real Estate Holdings, R2 Partnership, and R&D Real Estate Properties. I think one of the key points here is that this is only a challenge to the procedure employed for my client to seek demolition of the property. The substance of the use variance granted was not challenged. And in this case, the UDOD district guidelines require certain things that simply do not adhere to the 4 houses that are there. They require the building to be pushed up towards the street, and they require various elements that do not meet what exists at the site. So to even advance the intent of the zoning code whatsoever in this urban design overlay district, first and foremost, you have to get rid of the 4 houses that are well out of keeping with what the zoning code intends. And so with that, we have this demolition that has been sought that at the time, the way the law stood, it would exact a taking on the property for my client to be unable to demolish the property to build the multifamily housing that has been approved and not appealed for the site. And
Could it be a taking, considering that there were other avenues for you to be able to get these buildings demolished?
I believe it would, Your Honor. Where the claim asserted rests on deprivation of property interest, the constitutional right invoked is procedural due process to notice and hearing, which is, did the owner have an opportunity to be heard at a meaningful time and in a meaningful manner? In this instance, the only thing that they can get for administrative relief was a use variance, and that is why the ZBA in the prior decision opted for that path.
But your client still could have gotten legislative relief. Could have gotten the ordinance notwithstanding. It could have got a change in the zoning code, which ultimately is what happened.
Correct. And the difference there is that the notwithstanding ordinance, being a legislative process, has a series of formalities that would undermine my client's due process rights. The 2506 appeal process has formalities in it that protect their rights. It is for specific rights in a specific party and a specific property. They have formalities that are like a trial. They have opportunity to be testify under oath, for opponents to be subject to cross-examination. That is simply not available in the legislative notwithstanding ordinance process. And if that council enacts that legislative action, granting our notwithstanding ordinance or denying it, it really denies all the parties here any kind of remedy like you would have in the 2506 appeal. In a 2506 appeal, you appeal to the court as has been done here, whereas with the legislative process, there is no ability to do that. There is simply the referendum process or pursuing other declaratory actions that don't carry the same preservation of property rights that we think are inherent in the 2506 process. So with that having been the case, we believed that was truly the only ability for my client to have their due process rights and property rights preserved, that the ZBA's decision to allow us to do that was correct. And I will note that even in instances where whether something is a use is ambiguous, and I can't say either way, I believe it's clear that here it is definitely something that is regulated under the use variance process, as Mr. Tidd had stated. However, even where it is ambiguous, an ambiguous question, that ambiguity goes in favor of the property owner. And here the property owner isn't even asking, please err on the side of my property rights to grant me relief. We are saying, please err on the side of our property rights to allow us to simply be availed to a process where the opposing party had an opportunity to oppose what we were requesting.
you're saying the zoning code here is ambiguous?
I do not believe that it is. I believe that a use is clearly part of what the use variance allows. The use variance procedure says no variance shall be granted to allow a use not permissible, quote, under the terms of the zoning code in the zoning district in which the property is located. Under the terms of the urban design overlay district in the zoning code, we were unable to do anything, essentially. So we were asking to vary the terms of the urban design overlay district by allowing a demolition.
But there's no specific ambiguity that we're to construe in your favor, right?
I do not believe there is, but as an alternative argument, where there is an ambiguity, if the court were to find that, we still believe that it would err on the side of the property owner, recognizing that the property owner's rights to be availed to that process were favorable to us. We did so. It provided the opposing parties an opportunity to be heard as well. We had a clear and convincing evidence standard in that process, as opposed to the preponderance of the evidence standard that is typical in almost all other zoning relief in the code, and it allows all the parties to have the ability to appeal. So we believe that even in the alternative, if that were a question, we believe that the tie, so to speak, would still go to the property owner. And another thing that I would note on that issue is, again, this is an argument about, is the procedure proper? And harmless error doctrine states that a harmless error is one which does not affect the substantial rights of the party. Mere proof of a procedural violation by itself is insufficient to warrant judicial relief. Essentially, where the other party was prejudiced by the failure of the procedure, they may have an argument. But here, where this harmless error doctrine was raised even at the ZBA level, the appellants have never been able to articulate once at that level or in their briefs at this stage how this process has prejudiced them in any way.
Well, they're saying that demolition does not equal a use.
Correct.
And therefore, you shouldn't have gotten a use variance, period. I mean, isn't that just the simple, easy question that's in front of us right now? Does demolition equal a use?
I think that it is a little more complicated than that, in that the zoning suppresses property rights to the extent that we need to have our due process rights preserved. And so the question of whether that is even a valid zoning restriction to begin with has to do with, is it able to preserve our due process rights? And here, we believe that the use variance process allows us to have that preserved while not negating in any way the rights of the other parties.
And did you raise these constitutional and due process arguments below?
Yes.
Okay.
Yes. And for one more item, to the question of how this would affect other districts, again, while there are other procedures available for demolition in districts like historic districts where demolition is not permitted as of right, I will note that even if the city hadn't changed the code subsequent to our application, the use variance standards include in part that the variance will be consistent with the general spirit and intent of the zoning code. Just that right there, to me, I would deny a use variance requested stating for any kind of historic property saying, well, the intent of the zoning code is for you to avail yourself to the COA process and the historic board, not to be here in front of us. So I believe there are always protections in place to that effect, and that this is a very narrow circumstance that does not impact any other type of procedure inherent in the code. And then the final thing I would state is that, again, the notwithstanding ordinance, it's available to be relief from existing legislative and administrative procedures. And again, here, we're not asking for relief from them. We're asking to have the opportunity to avail ourselves to those procedures to protect my client's due process rights while also protecting the right and notice to the opponents to also be heard. And again, I think that's key here is that Mr. Tidd's argument in and of itself is complete, but even where you find otherwise, this process has allowed everyone a procedure that is adequate for what has been granted. And I have nothing else.
All right. Thank you.
All right, thank you.
So, Suter, you have 5 minutes.
Thank you, Your Honors.
First, in response, due process does not require an administrative process. There's process here. It's called the legislative process. And there's a right for everyone to be heard at the legislative process. In fact, there's a greater right to be heard in the legislative process than there is the administrative process, because in the administrative process, you have to have standing to be heard. In the legislative process, any citizen of the city of Cincinnati can be heard, including my clients, the Mount Lookout Community Council and all the residents of Mount Lookout who care about preserving their square. The intent of the UDOD was to preserve those neighborhood business districts the way that they are. And so the intent of the zoning code would have been not to grant, if you were following the intent of the zoning code, would not to grant this use variance, but we didn't get into the merits because we didn't feel we need to. That's a discretionary matter anyway. This is a legal matter, and there's a threshold legal matter, whether the use variance was lawfully used in this case. And we believe it was not, so there's no reason to get to the merits in this case. There's no right to a quick or efficient process. The legislative process maybe being slower than the administrative process, it's still a process, and there's a right to be heard. And that's the key. Convenience is not required. Law does not require convenience, and that's exactly what we have here, was a convenient way to get this development approved. But it wasn't a lawful way. If you look at what a use is, really key here also to that point about whether an administrative process, whether a use variance is required, is many cities in Ohio don't even allow a use variance. That is actually, in the planning world, a sort of a disfavored tool. Planners, and I'm a planner, kind of speaking on behalf of planners, at least myself, we don't really like use variances because we believe that that should be a legislative method, but
Now,
they're allowed.
when you say disfavored, does that mean by planners, or are you
Planners.
talking about courts?
Not courts. Now,
Thank
courts don't disfavor them, but they do say that they're an extraordinary remedy that requires an unnecessary hardship showing, which indicates that, look, it's different than an area variance, which just requires a low level of practical difficulties, 5 feet instead of 7 feet in a side yard setback. A use variance is a high standard because it's a big deal. Essentially, you're substituting the legislature's determination of what the permitted and conditional uses are. If you look at the term use, the Cincinnati Zoning Code defines principal use as the primary function of land or structures. It then also defines an accessory use as a subordinate, customarily incidental, and exclusive to the principal use. It does not define demolition as a use. It does not define vacant land as a use. And so the zoning code itself defines use. Term use is a term of art. This is in the Kipp versus Board of Zoning appeals case. This is over in the 12th Appellate District. But they hold that the term use is a term of art in zoning law. A use is activity permitted by the zoning classification applicable to the district, and it talks about two types, permitted and conditional uses. In the Young versus Board of Zoning Appeals, this is up in Montgomery County, it says a use is an activity permitted by the zoning classification applicable to the district in which the land is situated. Whether a particular use exists depends on the nature and purpose of the activity involved. That must be determined from the whole of the activity concerned, not merely with reference to one of its constituent parts. So even if you consider demolition to be one of the constituent parts, that's not what a use is under how it's been interpreted under Ohio law. So in closing, we don't have the substitution of a use. Demolition is not a substitution of a use. The use that they're hoping to use the property for, proposing to use the property for, is actually by right. This was a no demolition rule. The use variance was used to get around the no demolition rule. They had other means to do that. They had other due process, including the notwithstanding ordinance or a text amendment. If they wanted to pursue a taking, they could have done that. They never did. They've never asserted these constitutional rights in any court case. They may have argued about them, but they did not assert them against the city. That was certainly an option. Instead, they had what was really sort of a expedient way to get the development approved, but not a lawful way. Thank you, Your Honors.
Thank you. Thank you all for your arguments this morning. The case is now submitted, and we will issue a timely decision. Thanks. Have a good rest of your day.
Court of Appeals
He's a kid.